Hi guys, today I'm gonna explain to you guys about one of the subtopics from the elements of a valid contract, which is offer. Do you guys know what offer in terms of contracts refer to? Let's find out together. Offer is an unconditional proposal made by a buyer or seller to buy or sell an asset, which becomes legally binding if accepted. An offer is also defined as the act of offering something for sale, or the submission of a bid to buy something. Based on Section 2A Contracts Act 1950. When one person expresses to another his willingness to do, or refrain from doing something in order to obtain the assent of that other to the act or abstinence, he is said to make a proposal of making an offer. In this case, the offer can be accepted if it is certain, complete, and final to avoid misunderstanding. And then, when an offer is accepted, the terms in an offer will become terms of the contract. If an offer is uncertain, it is void, and any acceptance of that offer is also void. As an example for the case, I myself as a buyer who was the plaintiff in this case, while Alan is the seller that promised me that he would pay me several dollars if the horse was lucky enough. Vice versa, the horse was not in the condition of what that I believed, and the dispute arose between both parties as to whether the seller was owed the conditional payment mentioned by the buyer. Situations that could cause some confusion between two parties as whether there is a valid contract or not is normally in cases of advertisement of tender, auctions, advertisements, catalogs, and display of goods. There are many types of advertisements between offer and invitation to treat. Amongst them are advertisement of tender, advertisement of an auctions, and advertisement of a vacancy. Proceed to the communication of offer, based on Section 4(1) Contracts Act 1950, as stated above, meanings that an offer may be express or implied. An express offer is if it is made verbally or in writing. Implied, the offer comes from one's act or behavior. However, there is a situation where an offer can be a combination of both. As stated in the above examples, in order to make an agreement to exist, an offeree must know about the offerer before making an acceptance. If the offeree has no knowledge about the offerer while making an action that looks similar to the acceptance, it cannot be treated as acceptance. All of these are the other contract acts that related with revocation of offer communication of revocation. And that's all from us about topic and offer. See you in the next slide. Now, let's proceed to the second part of the topic, which is discharge of contract. Do you know what is the discharge of contract? The discharge of contract is basically parties to the contract which no longer obliged to do as agreed under the contract. There are 4 types of discharge, which is discharged by performance, agreement, breach, frustration. Let me tell you a bit about the concept of discharge in this topic. One day, a plaintiff, which his name is Mr. Cutter and he is a sailor, was hired for a voyage and given a promissory note from his employment that 10 days after the ship arrives at Liverpool, he will pay Mr. Cutter a certain sum, provided he proceeds, continues and does his duty as second mate in said ship from hence to the port of Liverpool. Mr. Cutter began sailing the ship as second mate for about 6 weeks, yet died before its arrival in Liverpool. Mr. Cutter's wife brought an action for a proportionate part of his due wages for the substantial amount of the voyage on which he acted as second mate. But in the end the court rejected his claim because the plaintiff passed away 2 weeks before the voyage ended. The defendant decided to pay the plaintiff's salary once in every 2 weeks. But after then, the defendant had failed to pay the plaintiff's wages. The plaintiff was angry and claimed the injury to the court. Vice versa from the previous case, the court allowed the contract to be rescinded since the defendant breached the contract. One day, the plaintiff and the defendant have met together and agree to deal an agreement. But the problem is the defendant did not fulfill his obligations when the due date came. Once again the plaintiff was so angry and claim an injury at the court. The plaintiff has the right to claim the injury since the storm that passed wasn't too stormy. That's all from us about topic discharge of contract. Thank you for hearing us. Hello, now I want to explain about capacity.
What is a capacity in law?
Capacity. Section 11 Contract Act 1950. Every person is competent to contract as long as of the age of majority, of sound mind, and is not disqualified from contracting by any law to which he is subject.
A person who is not of the age of majority has no capacity to contract and need attaining the age of 18 as stated in Section 2 Majority Age Act 1971. A person who is not of the age of majority is referred to as a minor. An agreement made by a minor is void ab initio. In India's court decision in Mohori Bibi v Darmodas goes, 1903, appellant gives credits to respondent, a minor. Respondent charges a house as a security. Respondent, through her mother, sought order from court to declare that the charge is invalid because lack of capacity to contract.
Type of agreement. 1. Agreement in relation to marriage, divorce, dower, adoption, religion, religious rights.
2.
Agreement of necessities.
3.
Agreement of apprentice or employment.
4.
Agreement of a scholarship.
1. Agreement in relation to marriage, divorce, dower, adoption, religion, religious rights. In Rajeswari Amp, Unor v. Balakrishnan Amp, Ors, 1958, defendant is a Hindu. He broke a promise to marry plaintiff, also a Hindu. When plaintiff claimed damages for breach of contract, court granted the claims even though plaintiff is a minor. Defendant broke contract of marriage which is made under normal practice of their customs.
2. Agreement of necessities. In Nash v. Inman, 1908, a tailor sued a minor to whom he had supplied clothes, including 11 fancy waistcoats. The minor was an undergraduate at Cambridge University. It was held that although the clothes were suitable according to the minor's station of life, they were not necessary as he already had sufficient clothing. 3. Agreement of apprentice or employment. A minor is bound by a contract of apprenticeship or employment as long as it is in the whole, for his benefit. In Doyle v. White City Stadium, 1935, a minor was bound by the terms of this agreement with the stadium when he agreed to undergo a training to be boxer. 4. Agreement of a scholarship. In Government of Malaysia v. Gurcharan Singh, 1971, Gurcharan received scholarship from government to attend trainings as a teacher, and for that he is to serve with government for 5 years after graduated. Gurcharan left before full term. When sued, he claims that contract is void. He was lack of capacity during that time. The court held that education is a necessity to a minor. Gurcharan is in breach of contract.